Chair, Justice Pitle, Mr. Gupta, Mr. Thiru, Dr. Hassanen, Mr. D. Alvis, co-panelists of this session, and the distinguished audience. I would like to start by thanking the Bar Association for inviting me to speak in this session, even though I am not from this discipline. I thought I would like to speak, given the topic, I would like to speak on a few minutes at least on the sovereign debt crisis India faced. And that was quite some time back, but everybody knows about it because that was the time India's economic reforms started. That happened in 1991. There were also, foreign exchange crisis, debt crisis earlier also, but they were not of that proportion to be called that they were crises. India did take loan earlier also, but after 1991, that is taken as a kind of success story for India, that they were able to meet the crisis and they were able to turn the table around so that it doesn't occur, at least not within the normal situation. The immediate trigger of 1991 crisis was again external, which Mr. D. Alvis was referring to, though it was external of that time. The Gulf War that happened in 89-90, the global oil price rise, export fall, world economic fall, and so on. And of course, the another political development that took place that time was disintegration of the USSR. Now, all these factors contributed, they were triggering factors. But the debt crisis in India, it was actually building up prior to that. The foreign trade deficits and fiscal deficit both were getting widened, and debt accumulation went beyond the safe limit. Then IMF, of course, there was an election, and after the new government was formed in the mid-1991, India approached the IMF for a loan. The loan, as we all know, IMF loans don't come without conditionalities. The conditionalities were there. Not only to correct the fiscal deficit and the trade deficits, but also that time the conditions also, at least broadly, it was to open up the economy to private sector. And this last point, that possibly was getting realized even in the Indian policy making circles. So they were getting ready towards that, how to open it up without the IMF loan. Maybe it would have taken longer, but it would have happened anyway. May not be exactly in that form. Now, in any such loan, as the chairman was telling, when there are adverse effects on the conditions, on the life of the people, actually, in a sense, governments are defaulting their own people. And that happened in India also, but possibly it did not go to an extent where people will come to the streets. Now, why did that happened. And it is here that possibly some of the success stories remain. Prior to that, India was a food deficit country. But by 1975, late 70s, India became a surplus food producer. And then it was intervening in the procurement and distribution of food grains market to a large extent. And slowly that expanded actually. By the time we took the IMF loan, it was quite extensive. It started during the World War by the Britishers to meet the food requirement of the urban area only. But slowly it expanded. So that possibly is one thing which helped the people at least to meet their food needs. And fortunately, a few years later, the Supreme Court interpreted in 2001 the right to food as an inherent part of fundamental right to life. So slowly, the expansion of the procurement and distribution mechanisms can be explained that way, and that was that was built of protection mechanism, at least for life. Later on, after meeting the crisis and long after that, in 2013, the Union government also introduced the National Food Security Act, targeting about 60-65% of the bottom population. So now possibly situation, at least on that front, is much better. Before that, the government also had introduced something to protect livelihood, not so much, but partially, about 100 days of employment to be guaranteed to any family in rural area who are willing to do manual work. Now this program called National Rural Employment Guarantee Program, it is named after Mahatma Gandhi. That also helped to some extent, and particularly that was evident in both the acts, the National Food Security Act and the NDIROL Act. Both the effect of that were actually evident during the COVID crisis, which was again, an external crisis. It was not a debt problem that time, but even then it was a question of life and livelihood. I will not say that the government met it perfectly or there were no improvements possible, but again, broadly speaking, possibly India did a good job even during the COVID time. Now, coming to some structural aspects, how did India avoid the crisis after 1991? One basic instrument for getting the economy on track and improving its living conditions is obviously economic growth. And except for initial few years after 1991, the economy came back to about 5.5–6% and slowly to 7–7.5% also. Again, it has come back to about 6–6.5% now on an average. That's the real growth. And with that, possibly the economic base of the country has expanded sufficiently now. I think there is also a political consensus, independent of whichever party is ruling at the center or even in the states, that after 1991 crisis, the consensus was to assign priority to fiscal stability in budget management. And that again brought in new rules, the Fiscal Responsibility and Budget Management Act in 2003, which put limits on fiscal deficit. Again, there were not rigid limits, as we saw during COVID, they were relaxed again. So in a sense, it was a kind of flexible, but not so much flexible role. Governments have to go by that. There are, of course, one can always say, accounting, jugglery and all that, but they are possibly within limits. One of the things that often it is criticized is there are a lot of off-budget loans which government guarantees, and that is not accounted for in the government budget. But again, at least most of it now is coming out in the union government budget last 4-5 years. It is explicitly. There are still, few things which possibly even the government machinery may not know that they have given a guarantee like that 8 or 10 years ago. Obviously, the legal framework needs to be strengthened to make it transparent and accountable, and particularly at the state level. The FRBM Act, they also apply to state governments in the federal system. But again, depending on time, depending on year, some states are going through their legislature and relaxing it. But again, overall, I think I'll say that broadly, states are also concerned about putting limits on their deficits, at least the major ones. I think I had a PowerPoint, I didn't. Okay, doesn't matter, I had given it but anyway, now, I have spoken most about, I'll not go more into Indian situation. Couple of things. Can I use it here, the pen type? Pen drive, can I use it here?
Can we have some technical assistance here for Dr. Panda?
Okay. Yeah. There is one file.
Right.
Now, some issues in the international context, since the topic was broadly around that. So, obviously, the need for preparing reliable, useful record of sovereign debt at the international level is a need, and without that, possibly international laws also might find it difficult to operate, what Chairman again was telling. But what should it cover? As I was thinking about it, I thought, what would it cover? For example, is it only union and state government debts, or in a federal setup only their union government? And possibly government guaranteed loans, say to the public sector enterprises. What about private loans guaranteed by the government? Then there are very innovative loan arrangements these days. For example, the resource-backed loan that is happening in some of the countries. Government may take it for, even advanced countries might like to take it for critical raw materials from a place like, for example, Ukraine. But there are also other examples. For example, between Chad and Angola, they entered into an agreement that Chad will supply cattle over 10 years period for repayment of 100 million of loan to Angola. They agreed on it. Now, how do we value this transaction over 10 years? If it is current transaction, we can value it at possibly current market prices. So these are the kind of questions that will come up. I'm just flagging one or two issues. Similarly, commercial concessions as part of loan repayment. Again, valuation of that as we go ahead in preparing the registry. These are possibly some questions that has to be addressed. Then if a debtor is not able to pay in the agreed upon currency, say US dollar, due to geopolitical problems, as some of the countries are facing problems. Then again, how do you, an agreed upon currency again has to be there to even to convert it to some international comparable currency. Which one? I'm only raising questions because since I'm not from this field, I'll not go into details. The other question that at least some of the people from my field, economics, they are raising is, if we have one agreed upon development goal by the UN, like the social development goal, if you have to finance that, because that is agreed upon, signed by almost all the countries, if you have to finance that, how do we have an contractual arrangement for that? Can it be somewhat relaxed? Who will supply such large amounts? Can it be like the one that happened for financing the redevelopment of Europe after the war? I think these are coming up. Then there is another problem which I would like to just again point out. For example, the hedge funds are very active in purchasing debt at a discount, and then they pursue for full repayment. So can the borrower be a party to it? Otherwise, the debt burden, why the borrower was not able to pay to the original creditor, was precisely because of certain inability, certain disability on their part. Now, if the hedge funds ask for full payment, the same thing will continue. Then again, there might be default-like situation. How do we avoid it? If we make the borrower also a party to it, at the same time allow some reasonable returns to the hedge funds because of their risk, that possibly could be one way, but one has to again, details have to be seen by the experts. But at the end, I will just raise one question, that who will govern international settlement? These are sovereign governments, or at least to a large extent they are sovereign on their own. If they don't agree to some international arrangement, what will be the mechanism for governing, for enforcing it? I think that's one point on which legal profession must come out and say this body must have power, at least in some spheres, to enforce the mechanism countries have agreed upon. Thank you very much.